Learning Unit 2, Obscenity and Indecency. Located on this screen is everything that will be covered in this video journal. Obscenity is the state or quality of being obscene, obscene behavior, language, or images. But what is considered obscene? Well, according to the Miller Test established in 1973, there are 3 components of what is considered to be obscene. The Federal Communications Commission, also known as the FCC, is an independent government agency responsible for regulating the radio, television, and phone industries. Their decision on what is obscene is similar to the definition given by the Miller Test. According to the FCC, the rules of what is obscene operates on the phrase, "I know it when I see it," written by Justice Stuart Potter in the 1964 landmark case on obscenity and pornography. In the FCC versus Pacifica case, a New York radio station aired George Carlin's monologue, Filthy Words. This monologue required him to say words that could not be spoken on public airwaves. Though there were warnings given to listeners, many complaints were filed, especially one from a man who said the broadcast came on while he was riding with his young son. After realizations made by the FCC, the ruling made by the Supreme Court was that the FCC may regulate radio broadcasts that are indecent but not obscene. The origins of the Miller Test came from a court case called Miller versus California. This case dealt with a man by the name of Marvin Miller who was convicted of mailing obscene materials with intent to sell to the masses. The brochure titled Sex Orgies Illustrated contained pictures of explicit images of men and women engaged in sexual acts as well as the prominent display of genitals. Some received the brochure and contacted the police. Miller was then convicted of a misdemeanor under California's Penal Code for knowingly distributing obscene matter. This brings me to important note number 1. If something is considered obscene, it is not protected under the First Amendment. Since obscenity is not protected by the First Amendment, the conviction was upheld by the Supreme Court in a 5-4 ruling. Local juries should determine what is obscene because the legal system has historically permitted triers of fact to draw on the standards of their community, guided always by limiting instructions on the law. In basic terms, this means local government decides what is obscene in their respective state or area. Samuel Roth was a person who operated a book-selling business in New York. He's convicted for mailing obscene material. This case can be seen as the prerequisite or the founding father of the Miller versus California case, being that it was argued roughly 16 years before, and it was also the first definition of what is considered to be obscene. Switching gears to some modern-day examples, the first one is Hanley versus the United States. It was a court case dated back in 2008 where a man by the name of Christopher Hanley was charged with receipt of visual representations of the sexual abuse of children and possession of obscene visual representations of sexual abuse of children. The next example is something that we discussed in class. Super Bowl 38, which was broadcasted live on February 1st, 2004 in Houston, Texas, was noted for having a very controversial halftime show in which Janet Jackson's breast, covered with a nipple shield, was exposed by Justin Timberlake for about half a second in what was later referred to as a wardrobe malfunction. Sometimes referred to as Nipplegate, led to an immediate crackdown and widespread debate on perceived indecency in broadcasting. The FCC fined CBS a record $550,000, which was fought in the Supreme Court and then later appealed and ultimately voided by the Third Circuit Court of Appeals in 2011 ruling, and a case to reinstate the fine was refused in 2012. Child pornography is material that depicts children engaged in sexual activities, whether it is by themselves, with other children, or adults. It is agreed illegal by both state and federal courts because its creation involves illegal sexual exploitation of children. Because of the New York versus Ferber case and the concern of child exploitation, New York law prohibited anyone from knowingly encouraging a child under the age of 16 to engage in a sexual act and then distributing photographic copies of the act. The Supreme Court later upheld this ruling. Paul Ira Ferber was a bookstore owner who unknowingly sold 2 films depicting children engaged in sexual activity to undercover agents. It should be known that child pornography does not have to be legally obscene under the Miller Test to be illegal. The Supreme Court ruled that many parts of the Miller Test are not applicable to child pornography, and this makes it easier to prosecute child pornographers. Though it is legal for adults to obtain obscene material in the privacy of their homes, it is illegal to own child pornography. In 1977, Congress passed the Protection of Children Against Exploitation Act, making it a federal offense for anyone to produce or market sexually explicit materials that involves minors, even if a film producer did not know an actor or actress was less than 18 years of age. In 1996, Congress passed the Child Pornography Prevention Act. This act banned images that appear to depict a minor engaged in sexually explicit conduct, advertising that conveys the impression that a minor is involved in sexual activity, and the use of unidentifiable children in computer-altered sexual material, basically putting a child's head on a nude body. Now I'm going to give you a brief introduction to what the PMRC is. Well, it stands for the Parental Music Resource Committee, and it is a committee formed in 1985 with the goal of increasing parental control over the access of children to music that is violent, have drug or sexual related themes, by displaying a parental advisory sticker. A notable founder is Tipper Gore, wife of Vice President Al Gore. In conclusion to this video, we have learned that obscenity has no First Amendment protection. The current definition for obscenity comes from the Miller case, and it is determined by certain criteria that was stated earlier in the video. People are allowed to have obscene material within the privacy of their own homes. Obscenity laws mainly target the makers and distributors of said material, and obscenity should not be confused with indecency. Child pornography is illegal due to the involvement of criminal sexual exploitation of children, and also child pornography possession is illegal.